We are live, or so says the control here.
We
So
are
welcome
allegedly
everybody.
we're allegedly live.
Yes,
We all could be AI bots. Nobody would necessarily know. And within a few years, I'm not even sure I'll be on the show, Kip. I'll just send my avatar, and you can. And actually, your avatar can talk to my avatar, and we'll be
that's
good.
right. I'll just be like, hey, can the Jake bot record?
And at the Jackpot where we play, it can always record wherever
That's
you
right.
want.
That's right, because it can spawn multiple Jake bots for any conflict.
That's
Okay.
right.
All right, so here we are live. I'm going to count down five, four, three.
So, Kip, what are we going to talk about today in episode 205 of the Cyber Risk Management Podcast? I love saying 200, Kip. I know I said I would stop doing this, but I can't help it. I really 205 episodes.
For a
Go,
podcast that
go.
only
I,
releases every other week,
yeah,
right?
go us. Go us. We've
Yeah,
had
if
some staying power.
man, if we had a weekly podcast, that would be like 410.
Yeah, I couldn't do that though.
No, we
There's a
couldn't.
reason. There's a reason we're not a weekly podcast.
There's a very good reason, and why we have an editorial calendar and a
Yeah.
backlog. I mean, because Jake and I are so busy. But anyway, all right, what else are we going to talk about today? Well, privacy compliance. And why is that? Because it's become so dang difficult and the complexity is just skyrocketing. And yet, businesses really do need to keep up. And so it really begs the question, how do you build sustainable privacy operations? Well, the good news is Jordan Fisher's here. She's the founder and partner at Fisher Law, and she's a cybersecurity lecturer at UC Berkeley, which gives her this rare and valuable perspective on the topic. And if Jake ever quits on me, I'm going to ask Jordan to be my co-host.
There
That's
you
how
go.
good she is.
It is Jordan. Jordan, welcome to the podcast. Why don't you go ahead and introduce yourself? Tell listeners about yourself. Yeah.
Perfect. Well, Jake and Kip, I'm so excited to be on here, and congrats, over 200 episodes. I mean, that is just such a feat. So you should definitely take some kudos on that. Very excited to be here. I live and breathe privacy, so really trying to sort of debrief on it, understand what's going on. That is what I like to do on a daily basis. A little bit about my background. I am an attorney. My introduction to privacy was a little different than most US trained attorneys. I actually clerked on the Court of Justice of the European Union, which is the highest court in the EU legal system. And that was my first introduction to privacy.
That's a whole podcast episode by itself.
Probably.
That's quite a yeah. And would that have been? That would have been pre-GDPR going live, correct?
That's what I was gonna, yeah, pre-GDPR. I worked for
Wow.
Kuhn Leonards, and at the time he was the vice president judge, then became the president judge of the court. And I got to work on some internet privacy cases under the directive in the EU. And that was the first time that I ever really dealt with privacy, because it's crazy to think.
And for those not as up to speed as Jordan and I on this, when she said the directive, she meant the General Data Protection Directive, which is the predecessor to the GDPR. In the European system, you generally get a directive first, then you get a regulation.
Exactly. So that was sort of my introduction. And then I came back to the States, and, there was murmurings of the GDPR, and all of a sudden businesses were thinking, what is privacy? I like to say I was training them how to spell privacy at the time. And it really just took off from there. And I opened my first firm in 2017, focused on data privacy, cybersecurity, and technology law, and working with businesses to understand the GDPR, understand the EU legal system, but knowing that they also sat in the United States. And then fast forward, I'm barred in California, and the CCPA came out, and it just has expanded since then. So getting to work with businesses across jurisdictions, whether that's just US state jurisdictions or international jurisdictions, to try to create some semblance of organization or clarity around what is going on, which is a moving target, it feels like, on a daily basis.
Not only just a moving target, but also a target-rich environment for our podcast, because there's so many things we could talk about. And I think we should start with the big picture. So I think your introduction has done a nice job of, starting to provide some clarity that privacy laws are multiplying. This is not just a US thing. Actually, our friends in the EU are really leading the charge here. So it's an international phenomenon for those of us here in the US. So Jordan, what are you seeing out there? Can you kind of give us that big picture?
Yeah, and I think the word complex and changing kind of captures it the best way. You have to remember that 10 years ago, we weren't dealing with all these different privacy laws. And that's pretty fast from a regulatory perspective to go from maybe one or two to 20, 30. It feels like every other day we're getting sort of new iterations on these different laws. And so that I think is the big picture, which is that this is not a stagnant place. This is not somewhere where you can say, okay, I have this privacy approach. It's going to be good for even a year in today's world because we have these new laws coming out. Then we have guiding regulations on top of those laws that are coming out. We have
And
guidelines. There's so
and
many
those
different
things
things.
are those things are hundreds of pages. The I mean the CCPA regulations are very long.
I like to call them Cal Privacy now because I'm, deaf by acronym. It feels like that's what they're going
Actually,
by.
you
They
know what?
rebranded.
I like that. I like that better. Cal privacy is a lot easier than it. I'm gonna try to train myself to do that.
Yeah, you're a
But thankfully
trendsetter.
we do have AI to help cull through all those those pages of data, right? So that's at least helpful.
We absolutely do. So look, at the risk of going off topic, or not off topic, off script, which I always do, shockingly. I'm just curious. The what do you make of the fact that 2025 was the first year since 2018 that no new state has passed a comprehensive privacy law?
Oh.
My sense is that we just got distracted by other things, and I'll just use the broad phrase geopolitical and national political events as a proxy for way too much stuff that is truly off topic. But that's my sense, is that it isn't that necessarily people don't care about privacy anymore. I don't think that's accurate. But I do think it's true that we've gotten distracted a little bit. I'm just curious what you think about that.
Yeah, I wouldn't disagree with that. I mean, between the geopolitical and sort of AI, right? AI has become this like
AIs,
dominant force
yes.
in every conversation. I
Hmm.
think though we had this huge wave of states, right? And they almost copied and pasted, right? They kind of just pushed forward. And what I'm seeing now when I talk to regulators in states that haven't adopted comprehensive laws is that they're looking and saying, what did those laws get wrong? And we want to get it right. The
Yep.
challenge is getting it right is really hard.
It is.
And there's a lot more stakeholders that I think are weighing in on what does right look like, which bogs down the process.
It does, and I think good examples are surprisingly hard to come by. We both teach at
Mm-hmm.
at law schools, and one of the things I pitch to my students is, we have all of these laws. Are any of them any good? It's just a provocative question, right? And I think the discussion oftentimes comes back to, gosh, you know what? I'm not sure they are. If we care about real privacy, or if we care about performative privacy, and there's a lot, like, I don't think we're there yet, right? I think we have a long way to go on effective privacy regulation, but I think people need to engage, right? If As I was just on a call yesterday, and I said, look, if people, first of all, if people cared deeply about privacy, they simply wouldn't use social media. But that isn't the case. So we have to figure out, what are we trying to protect? What is the best way to do that? And I think we're still working on it. I still think GDPR comes closest. And I think that the state laws would be more effective, but the thresholds of applicability are just too high, is
Yeah,
my
it's
personal
really
opinion.
it's funny. I've been using this term recently. People probably heard security theater, right? I've been using
Ah,
privacy
yes.
theater,
That's a good
right? So
one.
I've been saying like, is this really creating a actual privacy
That's
movement? Are we moving towards
Yep.
privacy, or is it just privacy theater, right? And I
Theater.
think privacy policies are a great example, right? Like, who's sitting down to read this privacy policy? But businesses have to do it, and then businesses get to check a mark that says, "Hey, I've complied." But
Yep.
does it actually create more effective privacy? And it's interesting. I'm doing some research on my academic side right now with a colleague in Milan at University of Bocconi, exactly looking at this, right? Like, are the laws is the end result of these laws resulting in more privacy, or is it just creating a huge cost for businesses, not really moving the needle on privacy and just creating all this
Ooh.
complexity?
Jordan,
I
you
think
go
that's an
right for
outstanding
the
question.
jugular.
Yeah.
Well, this is the conversation, Kip. It's one that I have in my privacy focused world, where you and I tend to be more on the cyber risk management
Yeah, yeah. Although
focused
there
world.
is a little bit of overlap, right? Because you
No,
can't do
no.
privacy
Yeah.
without cyber.
There's a fair amount of overlap, but they really are fundamentally different policy goals.
Mm-hmm.
But I think too, I think that with privacy, what do we really mean by that? Like, if you ask most people, hey, I noticed that you like to post on LinkedIn and TikTok and stuff. So maybe you don't. It seems like you don't really care about privacy. Are you cool if I just install cameras in your house and in your bedroom, in your bathroom? Like, no people will react instantaneously to that as like, are you creepy? Like, what is your deal? Like, you're crazy, right? So it's not the case that people don't have a sense of what privacy they care about. I think the problem is that they don't understand the impact of not having strong privacy on the internet. And to me, what changed my mind, because I will admit, I used to be kind of like, I have nothing to hide, I don't care. Like, that was me.
That's what everyone says. Why would anyone care about little old me?
Yeah. But then we had Cambridge Analytica, and that scandal really changed my view, because what I realized is that it's not really about, individuals' privacy, but really it's about the ability to collect vast quantities of data and influence people at the societal level. That is a danger, right? And I think that even though we're distracted by AI right now, and I think that, by the way, Jordan, I think that's the single biggest distraction from privacy. However, my contention, and I suspect you will agree, is that AI makes privacy more important than it has ever been by a huge margin. And that is why I think we cannot afford to be distracted too much longer from privacy.
Yeah, I think the best way to get people to understand is to look at Professor Zuboff's book, Surveillance Capitalism. If you want to understand what the real privacy risk is, that is where you have to look and to understand, because it's very hard, I think, for people to grasp how one interaction with the internet builds on this entire lifetime on the internet and creates these dossiers about you. But it's hard. The human nature is we want to move fast. We want to get things done. We like making it easier. And it's hard to grasp the magnitude of data that could be collected on the internet. It's hard for me, even knowing what I know, it's hard.
Well, and here's the other thing too, is like, I've deleted certain apps off my phone, but like, have you ever experienced, Jordan, like we know, we have to be in the top, 0.001% of people who ought to know what's happening when you look at an algorithmic feed. I still get sucked. When I look, I still get sucked in, even though I know exactly what it's doing. It's so effective. Yeah, I still get sucked in, and you can't separate.
It's like nicotine.
It is. You can't separate out the large scale problems of algorithmic addiction, of doom scrolling, of kids using social media from privacy. They're all connected.
Well, it'll be interesting to see the cases that we literally have testimony this week on, looking at this exact issue, right? Like, is that truly what's going on? I think we all have thoughts on it, but I'll be interested to sort of see where those court cases go.
Yeah, absolutely. Okay, sorry, that was kind of a distraction, but also totally on point. So,
one thing, Jake, you said that, not to get it off of the distraction, that I will tie it back to like the practical side of this, is I think that we as a society have not had the conversation, what does privacy mean to us? And in some ways, Europe has had that conversation, which allowed them to adopt the GDPR. And whether you like the GDPR or not, I think it's forced us to engage in privacy, both on the business side and the society side.
We haven't had, I haven't said this in a while, but I used to say years ago when GDPR first came out, when people were they didn't understand it. And I said, look, here's the question you have to ask yourself. What if Hitler had Facebook, right? And that is the essence of the GDPR. That is the essence of Europe's experience with privacy.
That's right.
And it is really critical to understand that this isn't just about opting out of cookies on, and being tracked for purposes of selling you something,
But
right?
I like cookies. They're yummy.
Yeah, well, you
Not
do
the
like
good
cookies.
kind.
Yeah. And I that's what I try to get people to understand when they're like, who cares?
Right.
I'm like, no, you really should care. And
Yeah.
that's why for me, the Cambridge
Because
Analytica was like, it's you look, you can manipulate an electorate. Not that, I would argue, look, there's always been propaganda. There's always been attempts to manipulate the electorate. I would say that's just the concept of politics and campaigning in any democracy. But when you can artificially put your finger on the scale using weaponized psychology and do that at scale, particularly adding in the power of AI, you move beyond, just persuasion and typical interference to actually dangerous levels of manipulation. And that's
the
the
opportunity for
criticality
abuse.
Yeah.
Right.
Yeah.
But I think
I,
part is, Jake, you're talking some pretty powerful companies who know what data they have, they can manipulate it. Where I find it really challenging in the current privacy environment is so many of these laws, that's what they're thinking of. They're thinking of Cambridge Analytica, they're thinking of Meta, they're thinking of Google. But what happens is a lot of small to medium-sized businesses, they have to deal with the consequences.
That's
and
true.
they're sort of stuck in the middle, right? Like
They
they
are.
have to comply, but they're also relying on AWS, Microsoft, Google, these tools. And they're like, well, I can't force Google to stop doing this. I didn't develop the internet, but I need to survive as a business. And I think that's where I find it's really hard with these current compliance laws, because they get stuck with the hardest job. They can't control the internet. They can't control the backbone that they're working on, but they have to comply with laws that were drafted to attack companies that are doing things that they can't even conceive of doing. They don't even think of themselves as data companies.
So what's reasonable,
that's right.
Jordan? I think that's like one of the huge things we want to unpack is what does reasonable privacy ops mean for companies that are not
and
the
Kip,
giant ones?
before we answer, we ask Jordan to answer that question. Let's just briefly define what we mean by privacy ops,
right.
privacy operations, because I think when people talk, we'll talk a lot about privacy compliance, right? We'll talk about cybersecurity operations, but you just said privacy ops. So Jordan, let's start with that. What does privacy operations mean to you?
Yeah, it's a great question. Because privacy compliance to me is let's start macro and then we go in. Privacy compliance is what can or can I do? What should I do around the legal infrastructure?
Yep.
Privacy ops to me is how do I make it real on a day-to-day basis for my business? Have it, like, let's take an example. Under Maryland's law, right? I have to do data limitization, right? It's much more aggressive than sort of other areas. I have to be very clean about what I collect and then how I'm using it, et cetera. What does that mean for John Smith in finance who has to deal with data? How do we make that real for him? And to me, that is often the missing link, is how do I take these broad brushstroke requirements under the law? And this is what gets tech people all the time. It's not like an ISO framework. It's not a controls-based framework. It is an end result oriented law that says you can't do X. And how do I say to a business, okay, now make that real for you? What does that mean in your day-to-day operations? To me, that's what privacy ops means.
Yes, and it's trying. In our words, Kip, it's operationalizing
the security policy.
The security policy, right? And it's like if I tell tech people or security people who often get stuck with privacy, hey, here's the deal. I'm going to need you to not endanger the dignity and freedoms of natural persons, which is language that the GDPR has, right? It uses this language.
Right.
You're going to look at me and blink your eyes and be like, dude, I don't even know what you said, let alone where to start on how to do that.
And it's so far beyond their pay grade, right?
So far beyond.
They can't even if they understand the requirement, there's nothing they can do about it. Based on their job description, they're not set up to succeed with that. I remember when in 2005, 2007, something like that, when I first was approached on the job, I was working as a CISO, and somebody started talking to me about privacy. So I went off and I tried to kind of get smart on it, and I realized, and I came back and I said, look, a lot of this privacy stuff is just about not collecting stuff you don't need and deleting it when you should. I can't help you with any of that. Those are business decisions.
No, that's right.
And you can, once you know what those decisions are, I can help you with a records retention policy. I can purge records, I can make sure those records are purged, so on and so forth. But if, I cannot lead this. It would be inappropriate unless you want to make me also the chief privacy officer, but I really don't think that's a good idea.
And I always like to explain to people, security cares about sort of somewhat of the perimeter, the control sort of in the data, but we're like, security is not concerned about whether we should have the data or not.
That's
right.
correct.
Like they're like, you have the data, I'm going to protect it.
That's right.
Whether you should have that data, that's a privacy question.
Exactly. Yes, Jordan.
Yes.
Thank you.
And
Well said.
that's exactly where I was going to say too, is that this is the difference between privacy and security. Is they overlap, but I don't want to overstate.
And they're
the
interdependent.
overlap. Well, not quite. Privacy is interdependent on security.
Oh, it's dependent upon.
Yes,
Yeah.
but frankly, if I want the highest possible security, I have a zero privacy world.
Yeah,
And that's
right.
that's
the trade-off.
that's the trade-off. Yeah, I mean that is
Yeah.
that's the surveillance police state. Forget surveillance capitalism. The most secure is the least private.
Mm-hmm.
Right.
Exactly.
So just
And
don't
there is
collect
that
anything.
Yeah,
Mhm.
which again is the point is really here that just they're related,
Okay.
but they are not the same.
So now that we've defined it,
Yeah.
what does it mean to be reasonable when you're doing privacy operations? What does it reasonable mean?
And I think we're about a decade too soon to maybe answer that definitively, because we
hold,
need to
please.
see, I know, we need to really see how this is going to look. But I think, and this is the hard part, because so many businesses will come to me and say, we can do X. Is that going to be enough? And it's like, I don't know yet if that's going to be enough. We don't have enough cases. We really, in the United States, we only have California weighing in on what these privacy laws even mean.
And how many, Jordan? How many hands does it take you to count the number of actual enforcement cases?
Yes. I mean, and what's a little challenging for me is what I'm seeing from the regulators so far is not really an understanding of the limitations of technology or an understanding of your reliance on third-party vendors. So we've seen California say numerous times, your decision to hire a third-party vendor, often in the cookie consent management platform context, is not going to excuse your non-compliance.
I am the choir. Jordan, please continue preaching.
And it's hard because I have businesses who say, I'm not a tech business. I'm not going to go out and bring in a dev team and code out my own cookie compliance consent management platform. I have to be able to rely on
I don't even know the questions to ask to do that is kind of where a lot of people are.
And it's tough. I mean, part of you wants to look at the platform and say, hey, what are you doing wrong? But it's also these configurations are customized to each website. And that's the challenge, is that you have different tools being dropped on these websites. You have different different ways that each business is using it. I wish I could say, okay, every business is going to do it this way, then it would be a lot easier. But so my whole point on this, going back to the reasonableness question, is it feels like a moving target right now, which is really hard for businesses, because a lot of times my clients say, listen, we didn't create the internet. Cookies are necessary in some way for the internet to work. Now, I do think there's if you have your marketing team, which continues to be the black mystery box for a lot of businesses, dropping a ton of cookies and they don't know what they're doing, maybe we're moving more towards unreasonable. But it feels like in today's world, you can do everything right and you can be minimizing it. You can be giving, it's opt-in, consent, everything. But you're being held to potentially a very hard standard to hit in the current technological environment. And that's just regulators. And then we add on SIPA litigation that we see going on, which is the California Invasion of Privacy Act, where we see some law firms really trying to push a narrative on businesses around cookies. And then, frankly, what I'm concerned about in the current environment is businesses throwing up their hand and just saying, listen, I can't win, so why would I try? And I think that is the ultimate worst outcome for everyone.
Kip, that's a conversation that you and I don't have very often, but the amount of time I spend on SIPA demand letters and complaints, I mean, there's a partner of mine down in San Francisco, and then an associate down there as well, and the three of us have handled, I think we've handled 36 in the last year. Like it's like, I feel like we get a punch card with these law firms.
Yeah.
Like, okay, fine, we'll let you off this time because this is your 10th one. You get your 10th one free, but it's a problem.
Oh,
Yeah.
man.
And the thing that really, I understand the need for pushing businesses to really put in place privacy, right? Some businesses need that push. I get it. I totally get it. What's hard for me is when we're pushing, but for what better outcome? Like, is this actually going to make people's privacy better? Are we stopping some nefarious use that is going to be better in the long run? And what I'm seeing instead is that the industry is just getting mad. And then they don't want to spend money or resources to do anything because they know they're going to get sued or they're going to demand letter, and they have to devote the cash to that.
Yep.
Right. Exactly.
And the really interesting thing about the SIPA issue, which is by the way the wiretapping statute, it's not and California is not the only one. I mean,
is
most
SIPA an
states
acronym, Jake? What does that mean?
Yeah, well, this is what makes it so fun and confusing. It is an acronym, and it stands for California Invasion of Privacy Act.
Oh.
The problem, though, is that it's actually the Wiretapping Act from like the 70s or whatever, and most states have one, and it gets really confused because, of course, it doesn't sound that different than CCPA, right? There's only one letter difference, CIPA versus CCPA, but the fact is that they're very different. Frankly, the CIPA, the SIPA, the wiretapping statutes, it's an abuse, but the way that plaintiffs' lawyers have done this is they just make sure that they offer a low enough settlement figure that it's literally not worth fighting. And that's their business model. And it's a temporary business model because eventually case law will solve this, I hope, or the legislature will, I hope. But you can't, the only way to win is to introduce a UK style blocking cookie banner, which at least arguably means that you've only permitted the strictly necessary cookies to be loaded, and there is no wiretap. There's no interception of communications, which is based on the third-party marketing cookies and marketing technology. It's not just cookies. Technically, it's also like beacons, pixels, JavaScript, etc. All that stuff together. And this is the argument. And what I tell clients is, look, you have to choose, right? If you put up a UK style blocking cookie banner, which also means blocking scripts, etc., then you have a pretty strong argument that you're not liable for wiretapping under these wiretapping statutes, but you're giving up your entire performance marketing, your ad tech, and that might be okay, but if you're a social media powered, small business, it's death, right? You can't give that up.
You can't
compete. You won't get traffic, right? You can't survive without traffic, and understanding your audience and your customer base. So
it's like opening up a store in a cow pasture. It's like, no, I gotta be on the street.
And what's really infuriating is then when they ask, well, does the law require this? I'm like, no.
No. The regulations don't.
No, I mean, the California Consumer Privacy Act does not require this. You're dealing with a wiretapping statute that a couple people convinced enough judges should apply. It's a hard conversation to have.
It's a very tough one.
And that's why they get mad, because they're like, this is ridiculous. And I'm like, it is ridiculous.
Okay. So, but we still need to get back to the question, try to answer the question, what does reasonable mean?
Well, we're talking about it. We are, because
but we haven't gotten to it yet, right? Just, I didn't hear the answer. Is there an answer? Because in cybersecurity, when I say, what does the FTC say is reasonable, right? We've been able to infer that it means, blah, 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 blah. We've actually come up with, a definition of reasonable cybersecurity, even though it's, you can't touch it and hold it, but it does talk about, data, given the sensitivity and the amount that you collect and compared to other people. Is there something like that for privacy?
It's tough because, the nice thing about cybersecurity is it's technical, and we do have technical frameworks under NIST, ISO that we can point to help give us guidance. We're starting to see some of that on privacy, right? Like ISO did put out their sort of privacy that sits on the ISMS standard, et cetera. But it's really hard with privacy because, and I think, Jake, you said this earlier, or maybe Kip, you did too. It's the business decisions that have to be made. It is every business team. So I can't set a technical control and say that's reasonable. And the reason is everyone's using data differently and everyone is accessing their data differently. And honestly, most businesses aren't even probably using their data because they don't even know how, they don't know they have it, or sort of
That's
it's sitting somewhere,
absolutely
etc.
true.
So in fact, it's a
Yep.
liability and not even an asset.
Okay.
But it's hard because what one business could gather data and they could use it in one way that's totally lawful, and another business could gather data and use it in a way that's totally unlawful. And it's because of the way you tell people, it's the what you're doing with it, it's the different data elements you're collecting. So that's what's so hard
Okay,
about
so these are
privacy.
practices. These are
Yeah.
practices, not policies.
There is,
but
yeah,
practices.
practices. And here's another way to think about this. Imagine a spectrum of compliance challenges and kind of understanding what you're supposed to do, of like, you know, the reasonableness concept. On the one extreme, you have EPA level environmental regulations that say, thou shalt not dump or
Discharge toxic waste
discharge.
into
Thank you. That's the
streams.
word. Thou shalt not. But it's more than that, Kip. It's
Okay.
thou shalt not discharge this chemical at higher than this concentration of parts per million over this period of time. It is essentially a mathematical, scientific, like, I can tell you whether you have complied or not. Now you move up this level of abstraction to cybersecurity, which is harder than that, right? Because I can't write a regulation that says this. And why? Because fire doesn't innovate, but or the environment doesn't really innovate. Like, pollution is pollution, but bad guys do. So I can't do quite the same thing, but at least I have a relatively clear goal, right? Which is basically to prevent unauthorized access, to protect confidentiality, integrity, and availability of all data, right? Then you move to privacy. Now, it's at another level of abstraction, because
beyond
it isn't
where we just were.
Beyond where you are with even cybersecurity, and it's way far away from the issues that you get with environmental law. And it's very challenging, because again, when you look at the foundational principles, they do fundamentally deal with the rights and freedoms and the fundamental dignity of human beings. That's a philosophical question more often than not. It's not something that you can give to your cybersecurity operations guy and say, make this happen.
Well, Jordan, aren't you glad we invited Jake to be on our podcast? Because he's doing such a nice job of explaining everything.
One thing, though, I was going to say that I
this is what we do.
Yeah, I appreciate under U.S. law, and I think we see tendrils of this under EU law, but I think it's more highlighted in U.S. law, is this concept of sort of a risk-based approach.
Yes.
And I think what U.S. law is doing, and this, so I'm going to say reasonableness is risk, right? And that's how you're going to find your reasonableness, because U.S. law is increasingly saying not all data creates the same risk for individuals, which is true, right? Like, my name is on LinkedIn. So yes, under EU law, I would have privacy, but what's the real risk, right, of people knowing my name?
Right.
So the risk-based approach, I think, is how you get to reasonableness, because that's going to allow you to have that discretion and to say, we're collecting name, and every name we have is on LinkedIn. And so the risk is pretty low. So our privacy controls can look different, as opposed to me collecting biometric information, which is going to have a much higher risk for the individuals. Now, all of a sudden, my privacy reasonableness is going to look very different. So that's where when I'm talking reasonableness in today's world, a lot of times I'm talking about risk. And the way that looks in privacy is privacy impact assessments. That's the sort of magical term.
I haven't heard of that before.
Privacy, data protection impact assessments, privacy impact assessments. We're starting to see AI risk assessments that kind of are building off that same concept.
So are you saying an impact assessment and a risk assessment are synonymous in your world?
Not 100%, because I think risk is, but close. Yeah, I mean, I think they're the same. They're the same sort of backbone. It's just when you're talking about a privacy impact, your questions might look different than a traditional risk assessment, right? Because in the privacy world, I care about the impact of the privacy of that data. I'm not as concerned about the broader risk impact to the organization. Whereas when I think risk assessment, I can sort of balance a little more with like the organization risk versus other risks that might come up.
Interesting. So, because okay, because when you said impact statement, I thought environmental impact statement, right? Because that got me back into the EPA sort of thing that Jake had mentioned. That's
I
what
think
made me
that's
wonder.
closer,
Yeah.
actually. I
Yeah.
think that actually would be a reasonable. That's a decent way to think about it.
Okay. Okay. So it would be like an environmental impact statement, but without the per parts million chemical, all the science and
Well,
all
you
that
could,
stuff.
there's some mathematical, like
There
for
is?
a lot of businesses, you could say, okay, if I have 10,000 individuals and I collect on them these 5 different data points, and I have,
Uh-huh.
you know, there is some math that you can do. I mean, at the end of the day, this all has to boil down to sort of what's the ultimate impact or risk. And there's some, you know, the probability, the impact, you know, you still do that similar. For some of this, you can break it down to math. Some of it you
Okay.
can't, but there could be some math.
So okay, so let me just kind of do a heading check here on this episode, right?
Mhm.
So we've sort of defined what privacy ops is. Then we talked about what's reasonable privacy, and so and then we layered on top of that this idea that different technologies like biometrics or AI or whatever can make things, you know, even more complicated and more difficult to discern. We talked about risk assessments, impact assessments, things like that. Okay, here's the thing. We're running out of time. So, Jordan, what's the path forward for our listeners who want to do reasonable privacy, want to practice reasonable privacy? Like, you know, what would you tell them?
Yeah, I would say you have to stop reading the headlines because you could open up your computer and every day Europe's doing something else. They're adopting a new law, a directive. The CCPA is coming out with new regulations, et cetera. That's important. I'm not saying it's not important, but I think that for every business, you have to do the basics before you can get into the nitty gritty of all these different laws. Because at the end of the day, all of these laws are going to require you to know what data do you have, right? And that's just old school data mapping. And the law is not going to tell you how to do that, but you need that output in order to effectuate some of the legal requirements. So the questions of how am I getting this data? What am I doing with it? And then what happens when I'm done? Does it go sit in a warehouse? Do I sell it to the highest bidder, right? Or anything in between, right? What happens when I'm done? Am I ever done with that data?
Okay.
What tools am I using, right? Because AI, while it's a distractor, is one of many tools that I could be using with that data. And that's going to sort of be a piece. So a lot of times when I'm talking to businesses, I say, don't get too caught up here, right? With what's going on in the world and everything that's going on. Let's start with some very core things, which is what am I collecting? What am I telling people I'm doing, right? At those key collection points. What am I actually doing with it? Am I using third parties? Because then that's going to give me my roadmap of where my risk is. It's also going to give me my roadmap of where I need to put in place privacy controls. If all I'm collecting is data on my website, let's say, and I don't use data from anywhere else, I'm not buying it from anyone, I'm not culling it from different data sources, then I know that my privacy notice on my website is going to be really key to setting up my privacy expectations.
Right. Okay.
And then I know my website is going to be one of my highest risk areas that I need to look at to see what third parties are touching it, right? So that's where you can make real progress.
Okay.
And then you can start to look and say, okay, so I need a privacy notice. Am I a California business subject to CCPA? Well, now my privacy notice has to comply with California.
And
but
I
don't
need an
know
attorney to tell me if I even have to do that.
Exactly. But I'll tell you right now, any client who comes to me, my first question is going to be, what data are you collecting?
Okay.
Are you even subject to these laws?
Okay.
Like, don't put the cart before the horse is kind of my biggest thing.
Okay. So, you know, it's interesting, Jordan, because one of the things that I tell my customers all the time is cybersecurity isn't really a technical thing first. It's a management issue first. There are technical issues, there's people issues, there's process and policy and all that stuff, but it's really a management issue. And I like that because, first of all, that's true, but also because when they understand that it's a management issue, they realize, oh, I have way more control here than I realized. And I that's what I hear you saying too for privacy. Am I right?
Yeah, it's a people issue, right? It's a department issue, and it's going to be set at that management level, but ultimately there is a methodical way to address privacy.
Yeah. Okay.
if you sit down and do the work of identifying your data and identifying then how that data aligns with the privacy
But it
components
sounds
to
like you
it.
just served me a big plate of soggy vegetables. I don't want to do that.
Nobody
That's
wants to do
awful.
it. Everyone goes kicking and screaming doing it. And I have to tell you, there's no tech solution out there that will do this for you.
Damn.
There are tech solutions that will help and can supplement and can certainly speed up aspects of it, but I have yet to find a single tech solution that removes the manual.
Despite the number of tech solutions that will claim to solve
Yes.
it all for you.
Right.
Yes.
Well, Jordan,
And
if you
some of them
can
can be
invent an
helpful.
easy button, you'll be very rich. You know that, right?
I would love to be able to do that, but if anyone's selling you an easy button, I would look twice.
3
Okay.
times. Easy buttons for this don't exist at this point.
Okay, well said, well said. So, we're coming down to the end of the time that we have together, which is unfortunate because in a way, we could extend this this conversation far beyond what we've done so far. But I think that's probably enough for now. But I would love to. You're a wonderful guest. I would love to have you come back sometime and continue the conversation. But let me just say, do you have any final thoughts for our listeners before we wrap it up, Jordan?
I would say don't feel like you're opening up Pandora's box, and don't think that you have to throw a ton of tech resources at this. I always say to everyone, opening up a Word doc and just starting to write down where you think data might be is an effective start. But the worst thing you can do is just think that it's going to go away or get easier in the future. Because unfortunately, what we're seeing now is more and more regulators are very focused on this. It's a very popular issue. It's an easy one to sell when you're a politician and trying to sort of make those connects, and it's going to come. And I think that the easiest time to start is probably yesterday, but then that means the second easiest time is today.
Okay, all right. Jake, any last words?
Too many.
Okay, all right, good.
So no.
Thank you. You've muffled yourself. I really appreciate that. You're obviously growing. Now we're in the 200 episode range. You're getting much better at this.
I figured it out.
That wraps up this episode of the Cyber Risk Management Podcast. Today we talked about why privacy compliance has become so challenging with evolving laws, rapid technology change, and how building a sustainable privacy operations function, or PrivacyOps as we've called it, but it can help a business turn legal requirements into practical everyday practices. Not exactly an easy button, but better. Anyway, we did all this with our guest, Jordan Fisher. Thanks, Jordan. We'll see you next time, everybody.
See you next time.
Thanks so much.